Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. This is our special Sunday edition. Our programming will return to its normal time Saturday next week. The topic today is the ballot initiatives that you need to know in order to protect your property. Well, hello, everybody. It's a special Sunday edition of Zoom Landlord Tenant Talk Radio. It is October 13th, 2024. I want to remind everybody that next week and continuing thereon, our normal Saturday afternoon at 3 p.m. will continue. Our next show will be October 19th, Saturday. With regard to the song, the name of the song was I've Had the Time of My Life. It was by Bill Medley and Jennifer Warnes. It actually was featured in the movie Dirty Dancing. And that movie first aired August 21st, 1987, 37 years ago. And I do remember that movie came out. And even though that movie and that song is at least 37 years old, that song is played and downloaded 500 times per month, ladies and gentlemen, 500,000 times per month after all these years. So it obviously is a very popular song. Okay, let's open it up to the topic of the day. And what is the topic? The topic is the ballot initiatives you need to know to protect your property. The ballot initiatives that you need to know to protect your property. Now, if we think about it, taxes are one of the most important items that are impacting our property rights, taxes. So let's take a look at California. Do you know that California ranks #1 of every other state in the union for having the highest income tax? #1. You might have thought it was New York. Nope. California, the highest income tax individual would be paying 13.3%. The next state down the line is Hawaii, paying 11%. New Jersey, 10.75. And we actually have to go down the list a little bit. Probably the seventh one is New York. Everybody thought New York had the highest state income tax. Nope. They're down on the list, 8.82%. By the way, of course, all these rates are terrible. And we have progressive states like Florida and Texas that have no income tax. I don't know how they do it, but actually, I think I do know how they do it, but that's what we're faced with. But let's move down the chart to other types of taxes. There's something called sales tax. Every time you buy something, you got to pay sales tax. So where do you think California ranks with regard to sales tax, with regard to every other state in the union? And the answer is, proud to tell you, California ranks #1 of all the other states in terms of having the highest sales tax. This just affects everyone, okay? Everyone. So what is the sales tax for California? Well, it's 7.25%. However, counties and cities may charge additional taxes on top of that. So for example, the city of Los Angeles is 9.5% every time you pay something. And why is this state facing a deficit crisis? Why? You've got the highest property taxes, highest sales tax, you've got the highest income tax, and yet they're sitting there crying that they don't have any money. Yet there's other states like Florida and Texas and a handful of other states where they don't even have income tax. So how is that possible, ladies and gentlemen? Let's move on to property taxes. Now, of the 50 states, California ranks 19th. So kind of in the middle, actually a little better. Now, why is that? And that is due to the Howard Jarvis Initiative, which was Proposition 13, passed many years ago, which limited our property taxes. But we'll get into that. But they are rating 19th. However, there's a continuing effort on the part of certain people in our state to erode the protection of Proposition 13. And make no mistake about this, ladies and gentlemen, there's a war being raged against landlords. There is a war being raged against landlords. A recent article was published by the LA Tenants Union, Los Angeles Tenants Union. And what they're adopting a position, just sit down and hold on to your seats. They're adopting a position that all rent payments should be suspended. Not that they should be lowered, they should just be suspended. We have the total socialistic viewpoints just cropping up from these groups. And that's what we're faced with, ladies and gentlemen. It's a total assault on property owners. Well, I talked about the topic, which is what we need to do to protect ourselves with regard to these propositions. So let's go over them. The first one is Proposition 5. This allows local governments to request bonds for affordable housing and public infrastructure with only a 55% approval. So it was that now, as the current law is, it takes 66.66% of the populace to vote for a bond to come in for local governments like Los Angeles and other municipalities. And that's why you see your property tax bill creeping up, even with Jarvis, because people are voting for these bonds. But at least right now, for the local jurisdiction, there has to be a 66.66% of people in favor for it to pass. They want to lower it. They want to lower it to 55%. This is for affordable housing and public structure. But guess what? Who do you think will ultimately pay for these bonds? And that's clear. It's us property owners. That's what it's going to be. So this is a big no on Proposition 55, a big no on Proposition 55. And if you read, when you go through your ballot, if you read who's opposing or who's in favor of it, take a look at that. Because, for example, in this particular Proposition 5, who's opposing it is the Howard Jarvis Taxpayer Association and also the California Chamber of Commerce. Well, I can tell you, anytime you see the Howard Jarvis Taxpayer Association on one side of a bill, that's the side you need to vote on, okay? It's pretty simple. So we're not going to give them the opportunity to make it easier to place more bonds by local municipalities so that our property taxes will go up. And by the way, we just all got our property tax bill, and I don't think we were happy with that. Let's move on to the worst one, and that is Proposition 33. Proposition 33 expands local government's authority to enact rent control on residential property. It expands local municipalities to expand rent control. Basically, what it's going to do is it's going to revoke the Costa-Hawkins Rental Housing Act. Now, what did that do? Well, Costa-Hawkins, and this was a law, the only law that was in favor of landlords, which was voted in back in 1995, guaranteed that there would be no rent control on single-family residences, townhomes, or condominiums. I don't care when it was built. I don't care who owns it, a corporation, doesn't matter. I don't care about AB 1482, the Tenant Protection Act. If you've got a single-family home, a townhouse, or a condominium, you are protected that you can raise the rent to market level. You can never raise it more than market level, but you can raise the rent. If this passes, it's going to allow municipalities like Los Angeles say, we're going to bring in residential homes, single-family homes and townhouses. We're going to bring that into our local rent control statute. What else does Costa-Hawkins do, which they're now threatening to take away? And that is it prevents local governments from imposing rent control on property built after 1995. So if you have a property built in 1980, it would forbid, for example, the city of Los Angeles or West Hollywood for instituting rent control on those properties. It guarantees this under the Costa-Hawkins Act. If Proposition 33 passes, that's all out the window. But as usual, it gets worse. One of the things that Costa-Hawkins guaranteed was vacancy decontrol. Vacancy decontrol. This is a pretty simple concept. You've had a person living in your property under rent control for 30 years. Finally, they vacated. The rent was way under market value. Costa-Hawkins says you can raise the rent to market level. If this passes, it'll do away with this guaranteed vacancy decontrol, which means that Los Angeles could say, hey, you got a vacant unit, I'll let you do 10% over what the last tenant was paying. Now you're thinking to yourself, would really a municipality really do this? Would they really pass laws for vacancy decontrol? They're not protecting an existing tenant. They're talking about a tenant who's not even living there yet. And the answer is, well, Santa Monica did this. That was back in the early 90s. They did it for their units. They wanted to have non-vacancy decontrol for their units and telling landlords what they could charge for vacant units. Well, of course, Costa-Hawkins was enacted, and then that part of the Santa Monica rent control ordinance was thrown out. So please, we must vote against Proposition 33. Very, very, very important. Okay. Now let's move on to the last one, which is Proposition 34. This restricts spending of prescription drug revenues by certain healthcare providers. Now you're thinking, what the hell does that have to do with me owning property, right? Well, certain healthcare provider receives revenues from the federal discount program, the federal drug discount programs. So that's what these health providers get. They get these income from the federal drug discount. Now, this initiative states that, hey, if you're getting this money from the federal government, and let's pretend you're the Cancer Association, this initiative states that you have to spend 98% of your money on those patients who need help. I mean, that makes sense to me. You know, if I'm part of the Cancer Association and I'm getting some kickbacks from the government based on this federal program, I should spend that money on cancer victims. Make sense? Well, there's a guy by the name of Michael Weinstein. He's the president of the AIDS Health Foundation, and his foundation takes advantage of this federal drug discount. But instead of using these monies that he's received for AIDS patients, what has he done? Well, what he's done is this is the third time he's brought forth this Proposition 33, where he's trying to make harm to property owners, to income property owners, and trying to affect our rights. Now, what business does this healthcare foundation take the money from the federal government and use it on their pet projects like protecting tenants? It would make sense to me that if you are a healthcare provider and you're getting federal monies, that money should go to your foundation, the one it started with. Why would you be spending it on tenant initiatives, Mr. Weinstein? But this program, this Proposition 34, we're going to vote a big yes on this because what it does is it stops Michael Weinstein from taking his money from the AIDS Foundation and doing some other pet projects. And do you know who's in favor of yes on 34? Who's in favor of it, in addition to every landlord and apartment association? The LGBTQ community is for yes on 34. They want money for the AIDS Foundation to be spent on AIDS patients. What a surprise, right? Okay, we've all got our ballots in the mail, okay? We cannot wait for November 5th. If you wait till November 5th, I don't know, it could be raining, you can't get out of your house, some person in your family has a medical emergency. We cannot wait. Get that ballot out as soon as this Zoom meeting is over and fill it out and send it in immediately. And I'm saying immediately, ladies and gentlemen, because we must defeat these propositions. So once again, we've got no on Proposition 5, no on Proposition 33, and yes on Proposition 34. Now, I debated whether I was going to tell you this story or not, and I'm going to tell it. So here's the story. My daughter, Madison Block, she is 31 years of age. She's been an attorney now for 5 years. She is a prominent associate in my firm. But when she was 8 years old, I was buying her a computer. And the computer arrived the day I got home from work. And she said to me, Daddy, I want you to set it up. And I looked at her and I said, Honey, I've got to go vote. So she said, No, no, no. And I said, Look, I'll tell you what, I'm going to take you to vote with me. And your two brothers have never been to the voting booth. She says, They've never been? I go, Yes. She said, Okay, then I want to go. So I popped her into my car. I get to the voting booth, and I don't know whether they're going to let us into the voting booth or not, but they didn't stop me, and I brought her into the booth. So she says, Daddy, how do you do this? And I said, Madison, it's so simple. Anytime you see the word Republican, you vote that way. Anytime you see the word bond, you say no. So she says to me, Dad, this is so simple. Well, there was a woman in the next booth over. I don't know what political affection of she was involved with. She's laughing so hard at my lesson to my daughter, which, by the way, my daughter did take my lesson, and we do have similar political views. So, anyway, that's my topic of the day. Thank you for listening. Please get that ballot out and please vote the right way. We've got to protect ourselves specifically against Proposition 33. It will be the death of our industry if they do away with vacancy decontrol. Okay, we are now ready for our opening for questions and answers. We know the rules that this is for informational purposes only. It does not constitute legal advice. If you do want to talk, please electronically raise your hand if you're in the Zoom room versus being on YouTube Live. And last but not least, if you do have a case with me, thank you very much, but we only discuss general questions here. And with that, I'm going to open it up to Jim Polina on a Sunday. How are you, sir?
Hey, Dennis, good to hear you again. Always love these meetings. So I got a hypothetical here for you. I have a tenant, gave 60-day notice to move out. They moved out within 30 days, gave up possession of the property. I'm advertising for a replacement tenant at a higher rate. I think I heard you say in a prior talk, if that's the case, I cannot hold them, the tenants that moved out, I can't have them pay the rent for the full remaining 30 days of their 60-day notice. Did I hear that right?
Yes, you did.
Oh God.
Under California law, you have an obligation as a landlord to mitigate the damages that your tenant it will suffer because they had an early termination of the lease. So if you had a
Okay.
one-year lease and they left after 3 months, then the tenant is still responsible for the next 9 months. However, a landlord is charged with mitigating the tenant's losses by trying to re-rent the premises. But if you try to re-rent it at a higher rate, then you can't hold the tenant responsible. You'd have to re-rent it at the same rate as what that tenant was paying.
So I owe them a refund.
I would think so, young sir.
Huh. Okay. Question two. A tenant claimed an emergency on a weekend because the AC failed and it's really hot. And I wanted to wait till the weekday to hire under normal rates the HVAC guy. They went ahead and hired the HVAC guy under weekend rates. Am I liable for that higher rate?
I think a landlord has an obligation to make the repair in the shortest possible time without regard to the fees at hand. So I think, again, you're on the shy side of this argument, and I think any court would hold against you. So I would allow them to deduct that off the rent.
I'm batting 0 for 2. Thanks, Dennis.
You have a good Sunday, my friend. Okay, we are moving on to Pauline. How are you today?
Mm-hmm.
Pauline, I think you're having a little technical difficulty with your microphone.
Hello? Hello?
Yeah, we're getting an echo, Pauline, so I'm going to give you another chance to figure out your microphone. I'm going to move on to Steve. Steve, I'm going to ask you to unmute yourself.
Hello, Mr. Block. How are you?
I am fine, thank you.
So I have a question in terms of changing the terms of the lease because the prior lease says there's no cap on attorney fees. So under Civil Code Section 827, we want to send a notice to limit attorney fees. My question is, how does that notice need to be served? Can it be taped on the property premise door? Does it have to be sent through first class mail by a server? Or,
I
or
would post it on the door and mail it. And by the way, that form is on my website. It's a notice, it's listed limit attorney's fees.
okay,
So if you go to my website, evict123.com, go to the free form section, and you'll be able to just print that notice out. You can actually fill it out on the screen. What you want to do is either hand it to your tenant, or if your tenant's not home, then you want to post one on the door and mail one.
thank you very much.
All right. Moving along to Pauline, I hope you get together. I'm going to pick Julia first, Julia Jordan. I'm going to ask you to unmute yourself, and then we'll go back to Pauline.
Thanks, Dennis. How you doing today? Hope
I
your
am
holiday
good,
were well.
thank you.
Good. Okay, so question. So I have a 4 unit in Inglewood, and the oldest tenant moved in back in like 2011, and I've never increased the security deposit. What is the maximum I can increase the security deposit?
Well, under the new law that became effective as of July 1st, you can only get a 1 month security deposit. But once the tenant's in, you really can't increase the security deposit. They've kind of changed the law on us a little bit. So, number one, you're only limited to 1 month's rent anyway, under the law.
Right.
So you wouldn't be able to raise it. I'm sure you have at least a 1 month security.
I do have the 1 month, but because of rental increases over the years, now it's maybe half.
Yeah, if you read the civil code dealing with that, they're not really allowing, once the tenant's in, that's what you can charge for the security deposit.
Okay, so maximum 1 month period,
You got it.
regardless. Okay, thank you.
Okay, we're gonna try again, Pauline. Let's see if you got your mic better because we were getting tremendous feedback.
Hello? Can you hear me?
Yes, you did very good. I'm proud of you.
Oh, thank you. I do have two questions. The first question is, last week we visited the tenant's condo and find his girlfriend with the baby come and talk to us. Then I asked our own tenant, I said, hey, is that person is living in the house? So his girlfriend already have the baby, and then we want to raise the rent because you have additional person living, coming to our condo. But they insist, they said, oh, she just come in, she did not live, she went back to her apartment at nighttime. So in this case, can I still raise the rent? Because they must be lying, saying, oh, they go back when they,
Well,
mhm, living
whether
at
they're
night.
telling the truth or not, it's irrelevant because this is a condominium. And as I said in my opening talk, that there are no rent limitations for condominiums, single-family homes, or townhouses. So you have the right at any time to raise the rent as much as you like. So whether she's living there or not. Now, if you were under a rent controlled statute, you would be able, for example, in Los Angeles, to raise it 10% for each additional person, but then you'd have to actually prove that she's living there. If she goes home at night, then that means she has another residence, and that means that she's really not living there. But we don't get there in your situation because this is a condominium. So raise it whatever you like,
Okay, so I can raise the what, but my
regardless of whether she's there or not. You can raise
mhm.
the rent to any level you like.
Even though our condo is under RSO.
Even though your condo is under RSO, and I'm going to explain what that means to everybody else who's listening, Your condominium was built prior to October 1st, 1978, which means that it's subject to the Rent Stabilization RSO ordinance for the city of Los Angeles. It means that you have to register the unit every year. It means that you need good cause to evict. But because of that wonderful statute uh, dealing with Costa Hawkins, there are no rent limitations on condominiums. So you can raise the rent as much as you like. That's why we really have to vote no on Proposition 33.
Oh, okay. So because we just raised the rent on February 1st, can I?
And raise it again as much as you like, whenever you like.
Oh, okay, good. And because this tenant, he lived in our condo with their parent when he was a kid, but all their parent already not here anymore. One passed away, one go back to their own country. So we create a new lease for this tenant when he grew up and was like back in around 19 uh, 19.
I get the situation, Pauline, but
Mhm.
ask the question though.
So is it on that one? If so did we base on the new lease or still based on he
If
when
he's
he lived in there?
If he signed a new lease, he signed a new lease. But again, I can't say it enough. It's a condominium, young lady. You can raise the rent whenever you like. All right, thank you very much. I am moving on to Ferry, Fari, Ferry. I think I pronounced it right.
Yes, Mr. Bullock, thank you so much. How are you?
I am good. It's Sunday. Sunday's
Is
the day we go out
son,
with the kids and the grandkids for dinner. So that's what I'm going to be doing
that's
tonight.
that's why I have my grandkids here. My question is, I have an ADU in Woodland Hills, Los Angeles, California, and I have a tenant which is going to be expired. You know, the lease is going to be done December 23rd. And unfortunately, today we had a police, involving with him, not because of me, because of he had some crime. And police advised me to start for, eviction, start to do, the process of eviction. I need your idea. What should I do? Yesterday morning, he texted to me, I'm going to be, this month is going to, next month, I'm going to move out. And I say, okay, just with text. And I ask him for date. And I didn't see, any response. And today, police told me he's in the jail, unfortunately. What should I do?
Okay, well, first of all, even though this is an ADU and probably not subject to RSO, the rent stabilization ordinance, because it's probably relatively new, it is subject to the just cause ordinance for the city of Los Angeles. So you do have to have a cause to evict. The fact that the police raided the unit and he's in jail, that's not a reason to evict. We don't know what he's done. If, for example, it's proven that he robbed a bank down the street, that really has nothing to do with you. So you'd have to have a reason to evict. And if you don't have a reason to evict, then he is a protected tenant. And the fact that somebody gets arrested or even committed a crime but did it in a different location, that it cannot be used for you as cause to evict. Now, if the guy's in jail, he's probably not going to be paying his rent. Does he owe rent for this month?
No, he's not.
Okay, well, hopefully he doesn't pay rent in November, so you'll be able to proceed forward with that. The fact that the lease is over in the city of Los Angeles, if he's been in the unit more than 6 months, which it appears he has,
Yes.
then you need cause to evict. So you can't say the lease is over, get out. That's why I recommend for the next tenant who moves in, make sure you just do it on a month to month. This way, after the fifth month, you can just say, hey, I'm not going to renew the lease and I expect you to leave.
Oh, okay. But for now, I can not do anything.
Nothing to do. He
Nothing
hasn't
to
done
do.
anything wrong. You don't even know why the police arrested him.
Pretty much I know, but I don't want to, talk about it.
Okay, well,
Yes.
if the crime is committed, let's say he was storing illegal drugs on your property, something to that, then that would be grounds. But if he did something someplace else, then it has
Is it
nothing
from,
to do.
yes, from some places, it looks like it was robbery, unfortunately.
Right. Well, he didn't
And
rob
yes,
you, so and
no, no,
and so
no,
it's
it
not
didn't.
cause to evict under the way they wrote the ordinance. Anyway, thank you very much. We are moving on to Scott. Scott, how are you today?
Hi, good Mr. Block. Thanks for hosting these calls. I've got two questions. The first one, we have a multi-unit building that had some flooding. The plumbers uh, decided it'd be best to shut the water off for a day or two while they resolve the issues. So my understanding is we're going to reimburse all of the tenants for those days that the water service is off, pro rata for the days of the month that it's off. I'm wondering if we have any other additional liability to them as far as if they want to rent a hotel or something like that.
Yeah, I get this question all the time. There's nothing in California law that says you have to put them up in a hotel. Uh, as you're doing, you're just giving them a per diem for the time that they cannot use the unit. So, for example, if the unit goes for $3,000, that would be $100 a day. So, for each day that they can't use the unit, you would give them a credit of the $100. That's why it's imperative to have in your rental agreement a provision such as the one in mine, which states that that tenants are required to have renter's insurance, which covers relocation for temporary periods of time when they have to relocate. So I like
Yeah,
that because it kind of sets them up. And you might want to check your rental agreement to see if that's contained in there. But I don't think you have any other obligation under the law.
yeah. Our rental agreement is the apartment association one. In one section it says that I think it recommends rental insurance. We also provide them with the F-39 form, um, the renter's insurance addendum.
Right, but again, a lot of times what those insurance provisions talk about, renters insurance, they talk about that we're not going to reimburse you for any damage to your personal property, but it doesn't go further to say that if you have to temporarily relocate, you have to look towards your own insurance company for compensation. I know
Right,
mine says that, and I don't know if the association says that, but I would take a look at it because then you can immediately point that out to your tenants. But again, I don't know of any law that says you have to put them up at the Four Seasons.
right. Okay. And then second question, in regards to the ULA tax in Los Angeles, mansion tax. If I recall, there was supposed to be something on the ballot coming up in November for the state that was going to essentially prevent individual cities from enacting taxes like that. And from what I heard, if that passed on a statewide level, it was going to, I guess, turn back the LA ULA tax. Have you
I,
heard of any other initiative like
I
that?
have not, and I went through the ballot and I've already voted, but I didn't see that.
Okay,
Okay, Scott, thank you very
thank
much.
you.
And let's move on to, says here, CY. How are you today?
Hi, how are you? Thank you for taking my call.
Now, what does CY stand for?
Oh, it's just Shar Young.
Okay. Char. Char, like CHAR kind of
Yeah,
Char?
yeah, that's right. Young.
Oh,
Anyway, thank you for taking my call. I have one question that has three subcomponents. I have a 4 unit complex and I installed some security cameras. I notified the tenants by mail that I was going to install audio and video CCTV cameras.
what was the first word you said?
Audio and video.
Oh, audio. Yes.
Yeah, I notified them of that. I also put up signs that state that there being audio and video surveillance on duty 24 hours. Anyway, so the cameras went up, and one of the tenants called me and has three issues. One, he doesn't like where the camera location is or the angle of it because it says it covers his side of his house, his door. It's not directly going into the door, but he wants me to move that camera. Am I obligated to? I don't, it's not going into his door. You can only see the side of the wall and people going in and out. Second thing is,
Well, let's go one at a time. You know,
okay,
when you get to be my age, you
uh,
can't have
I
long,
am your age.
the
I think
short-term
we're the
memory, you
same.
know. I would just tell them, no, this is where it's staying. It's not going in. It's not an invasion of your privacy. It's just showing the walkway and showing people who are coming and going, which is exactly what I want to know.
Okay. Second one is the audio. He says that he doesn't approve the audio He doesn't want that audio. It invades his privacy. That California is a two-party state, so he needs to sign something that agrees that he can be recorded.
And the
Um,
answer to that is he's 100% wrong.
okay.
California states that you can record somebody, but you have to alert them that you're recording. Uh, you can actually, it's funny, the law has no problems with regard to video, but with regard to audio, you have to inform the person that he is being recorded. And it's not that he has to agree to it. You just have to inform him. That's what the law states.
So by having those signs up there, it's informing anybody coming through.
And he knows it because he wants it taken down. So tell him, nope.
Got it. And
What's the third one?
the third one is he said he turned off the main breaker and realized that those cameras were linked to his electrical panel or his electricity. We don't pay, as a landlord, I don't pay separate electricity, so it's got to go towards one of the units. So my resolve is I think I'm just going to offer to pay him for some electricity, some power on there. But if he decides that he doesn't want to do that, then what is my recourse or what can I do at that point?
Well, he doesn't have to state, look, you're using his electricity and he has a right to say, I don't want you to use my electricity. I don't care about reimbursement. I don't want it. So what I would do is I would talk to one of your other residents and say, hey, look, I'm going to want to tap into your electricity and I'll reimburse you. Get somebody else to agree to it because quite frankly, he doesn't have to agree to that.
Yeah, that's what I was afraid of. So I was going to go out there and see if I could tap into another electricity. But
Now, there is another solution, and only because I'm kind of the IT guy
mm-hmm.
around here.
Okay.
I know that on the Ring camera, and I love that product, that it comes with an accessory which works on sunlight. So it's a a solar panel. And so you
Mm,
might want to investigate whether you buy a little solar panel and you plug your cameras into the solar panel. And this way you can tell everybody to basically go to hell.
got it. Yeah, I didn't get the Ring. I don't know. I will look into that because I hired a company to install it. I think
Yeah,
that's a good idea.
and you can get
Hmm.
it on solar because I know the Ring camera works on solar, so I don't think there's anything different. And so you get yourself a little solar panel or make a deal with one of the other residents.
Okay. All right. So if he says go to screw that, you're not going to let you tap into my thing, period, then I have to do that. Okay. Thank you very much.
Actually, I wouldn't even offer to give him money. I would just make another solution.
Yeah,
Oh,
that's
and
my
in the interim, I would also give him $30 for the inconvenience. What, because you already had them up, so he can claim that there was some electricity. It wouldn't even be close to $30, but
yeah, gotcha. Okay. Thank you so much. I appreciate
okay.
it. You have a great day.
Bye-bye.
Thanks. Bye.
Okay, we're moving on. I see Betsy. Betsy, how are you today? Betsy, are you there? There you go.
Hi, hi, how are you?
I'm good.
Okay, hi. Okay, thank you for taking my call. I have two questions. Number one, your lease agreement, number 35, exemption from statewide rent control. Check if applicable. I'm in Lowland Heights. This is an incorporated area. Do I need to check this? I don't understand this paragraph.
I'm happy to explain it.
Yeah,
That's why you're calling.
yeah,
Is this an apartment or a house?
yeah, this is a triplex.
Okay, so don't check that box. I presume the triplex is older than 15 years, correct?
Yes, yes.
Okay, so if this was a single family home in Roland Heights, then you'd want to check that because single family homes are not subject to statewide rent control. But your property is subject to statewide rent control, so do not check that box.
Oh, okay, thank you. And then second quick question. I have a little common areas, front yard and then side alleys. That what if the tenant insists wants to put his motorcycle in there? And then if something happened, it got lost, damages, who's responsible?
Well, doesn't the rental agreement provide for where people are supposed to park their vehicles?
Yes, parked vehicle in the open carport area, but that's
Okay, so
open
then
area.
just tell them you're in violation of your rental agreement. You're not allowed to park your vehicle. In this case, it's a motorcycle. You're not allowed to park it here, move it. And if he doesn't, then we have the right to bring forth an eviction based on he's violating a term of his rental agreement.
Oh, and just another quick question. You know that we have like inspection, that registration, and then also another registration. Every year you have to pay for each unit. What if you don't? If you don't pay, you don't register. What that
Well, if you're in an incorporated city of Roland Heights, okay, then there would be no registration, darling. So
Oh,
So
no.
I don't know what you're referring to. If you're unincorporated, that'd be a different story. But you're telling me it's an incorporated city, Roland Heights, and on that basis, there is no registration.
No, I'm not. I'm kind of confusing. In Lowland Heights, do I incorporated it or
I don't
unincorporated?
know. I'd have to look it up. It seems to me that Roland Heights is a separate city, but I don't know without looking that up. So you might want to save that to the office. But here's the deal. If Roland Heights is an incorporated city, okay,
Yeah, yeah.
then you would be subject to statewide rent control. There'd be nothing for you to register. If Roland Heights is an unincorporated area of LA County, then you are subject to the county ordinance and you're going to have to register your unit. In any event, you can check with me later at the office and I'll look up your property, or you can go to, it's the tax assessor for these. Actually, no, there's another site to go to, which is dealing with, let's take a look here real quick. It's the Los Angeles County Registrar. If you go to the website, the Los Angeles County Registrar, and I'll put a link when I do the editing of this. You can check whether your property is in an incorporated city like Burbank and West Hollywood or Los Angeles, or whether it's unincorporated. Anyway, thank you very much. We're going to move on to Bert. How are you?
Thank you, Dennis, for taking my question. Um, my question is regarding the AOA form, 30-day notice to change the term of your rental agreement. So you can change your monthly rent, security deposit, but then there's also an other changes section. Can you put in these other changes anything like, for example, the arbitration for personal injury or mandatory renter insurance or capping legal fees at $500?
And the answer is absolutely. All of those, I might add, are on my website. Those specific issues that you just talked about, they're all on my website, all filled in for you already. And you can do that by serving that notice, either handing it to the tenant or posting one on the tenant store and mailing it.
And they don't have to sign, correct?
No, you never sign a change of terms and tenancy. The only thing a tenant signs is a rental agreement. Anytime you
Got
do
it.
a rent increase notice, well, the tenant would say, well, I'm not going to sign it. So therefore, there's no rent increase. No, a
Okay.
rent increase or a change of terms of tenancy is not signed by the tenant. It's only prepared by the landlord and properly delivered to the tenant.
Is there any limitations on any of these clauses I can put in there
Well,
that I
of course there is. For example, if you're under rent control, and right now, for example, it's 4%, you can't do a rent increase that exceeds that, you know. So
understood. But any clauses, for example, from your rental agreement, if I don't have them in older agreements, I can
yeah, I
put them
mean,
in
if
there?
it's not violating any local rent control ordinance, and that's why you should go through on my website. I've got a bunch of different change of terms of tenancy, and they're legal to use whether you're under rent control or not. And with that, we're going to move on to Austin. How are you today?
Hello, Dennis. Very good. How are you?
I am good. Are you the Long Beach guy?
Yes.
Okay, got a fourplex in Long Beach.
Yes. Yeah. And last week you talked about almost all non-payment of rent arise from habitability. So
Well, more
this,
precisely, I said that when we file an unlawful detainer based on non-payment of rent, invariably the tenant will defend the lawsuit on the basis that the premises are uninhabitable.
Right. Thank you for that. So I have a non-paying tenant, and instead of responding with habitability, they said something to the effect of, landlord will not accept my payment of rent because I called emergency services to protect myself and my daughter from a neighbor. Obviously, this is not, I had no knowledge of this. So my question stems from, how far do I need to chase this to cover myself as a landlord? Because at the time when I found this out, the tenant made no written communication that she was calling emergency services for a domestic disturbance or a dispute with a neighbor, let alone one of my neighbors or tenants, like another tenant. And I was never contacted by the authorities, never received any police report, no, nothing like that. So since I didn't have any knowledge of this, do I really need to go calling, the Long Beach Police Department and say, hey, can you give me all records that, of phone calls or domestic disturbances on this property?
Well, I'm not following the logic in this. So let's take a deep breath. Is the tenant in their answer saying, hey, I didn't pay the rent because I was having a problem with a neighbor? Is that what she's saying?
Not exactly. She's saying that I would not accept her rent because she called the police on a neighbor.
But that doesn't make any sense. What does calling the police on a neighbor have anything to do with you refusing to accept the rent?
Uh, I don't know. That's why this is
Good.
kind
Okay,
of a
so if you don't know and I don't know, then here's what you're going to do. Absolutely nothing, because the judge is just going to scratch his head saying, I don't understand how this is a defense. Why didn't you pay him the rent? Okay. So
yeah.
I think you're fine on that one, because the logic escapes me as to the reason why she's not paying the rent.
Yeah, but one more follow-up question. So when I read this answer, I did the same thing you did. I mentally dismissed it because there's nothing that supports this allegation.
But
However,
even if it did, where are you not accepting the rent for what? It doesn't make any sense.
I agree. It's more or less, this is a tactic that could muddy the waters, which would have normally been a straightforward non-payment of rent standard trial.
Well,
But
I can tell you that any lawyer worth his weight would be filing an objection if the tenant raised this. So it would never come out because it's nonsensical. There's certain reasons the tenant can lawfully withhold the rent, but this is just nonsensical goulash. So I don't think when she starts to talk this way, assuming it's a she, your attorney would obviously object based on relevance, and this would get kicked out. I don't think it would ever get heard.
yeah, the only other twist is, a few days later, I did actually find out that one of the other tenants, was having a domestic that had multiple domestic disturbances with the non-paying tenant, and I get a text message saying, "Oh, by the way, I filed a restraining order against some of the non-paying tenants' affiliates. Here's a copy of it." So I think
So it's the person who's not paying the rent who's creating the problems?
her affiliates are, yes.
Okay, so I'm not sure what affiliates are. Is that like guests or guests are?
Yeah, her sister and another.
Yeah, okay, yeah, the whole thing. Austin, I wouldn't worry about this one. Okay, we're gonna move on to Anna. I'm gonna ask you to unmute yourself, please.
Hi, Dennis.
Hello, Anna.
Dennis, I'm trying to find out. I have a tenant that moved out of a LARSO unit back in 2022. He owed me rent for about 4.5 months. And when he vacated, he had given me his 30-day notice that he was going to leave. He wrote in his note that he wants to make arrangements to pay the portion of the rent that he still owes me. So, do you do this type of work, or is there somebody that you know
Well, you
that?
don't really need anybody. This is somewhat of a minor matter if you're only talking about 4 months worth of rent. So what I would do is just go down to your local small claims court and they'll fill out the paperwork for you. There's nothing for you to do except to pay, I don't know how much it is, like $75 or something. And then you can file an action. You'll go to court and you'll get a judgment.
Okay, yeah, because I don't think I'll collect it, but I'd like to put it on his credit report.
Well, we do collections, and a lot of times after we've evicted somebody, to try to collect against these people are is pretty much worthless. But what people don't understand is judgments are good for 10 years, and we'll keep checking it every year. And a lot of times in the third, the fourth, the fifth, the eighth year, we swoop in and collect because the guy might have no wherewithal now, but he might have wherewithal in the years to come. So I think it's a good idea to get a judgment against this person. Also, it'll go on his record.
Okay. Do you do skip tracing as well?
You want to find out where he is?
Yeah, because I think he's still
Has he been
here.
gone for more than 6 months?
Yes, but
And
he had a
are you a
sorry,
client of mine?
as needed.
Have you ever used our service?
Yes, sir.
Okay, then call the office and I'll do some skip tracing for you.
Okay, one last question, if you don't mind. I had a maintenance request to do a repair in a unit. We made arrangements to go in there. Um, this was a first since, they took off the COVID regulations and stuff like that. But this person wanted me to wear a mask and booties. Could I refuse? And then how do I go about making the repair if that's going to be the case with this tenant?
I would wear the mask and the booties. You're dealing with somebody who is hypersensitive to germs, etc. We are coming out of, quote, this pandemic period. So, and I've actually seen that looking for houses when I was looking for a house for my daughter. Some homeowners wanted you to put on these booties to get in. You know what? Just go with it. It's not that big of a deal. All right,
Okay.
thank you very much. Diane D., how are you today?
I am fine, Dennis. How are you?
I'm doing pretty good.
Well, that's good. Dennis, I have this ongoing situation that I'm trying to keep it calm with my tenants, but um I've raised the rent, and this last month they sent me a partial payment and I sent it back, and they're just kind of ignoring my communications with them, and I would rather kind of like negotiate something with them, but I don't have an excuse me, I don't have a rental agreement with them, so I was just going to send out the change of terms of tenancy just to make sure that they don't start subletting or
Well, you
doing
can't,
other stuff.
if that's not going to help you, you can't change the terms of a tenancy and then use that change to do an eviction. What, is this under
No, I wasn't.
RSO?
I didn't plan on using it for the eviction. I just didn't want them to start doing stuff because
Well,
the rent is
but if you have no teeth, then what's the point? If you can't do anything with the notice, they could just laugh at you and rip it up. But one thing that you said, which I don't understand why we're moving on to the topic you're raising now, you said the tenants didn't pay you the rent.
right.
So why don't we don't have to get to subrenting, darling? When you're dealing with a landlord-tenant situation, the only reason, the only reason a landlord has a tenant is to get the rent. If you're not getting the rent, the whole concept of landlords and tenants and tenancies is out the window. So if the tenant hasn't paid you the rent, and this is under RSO, I presume,
Um,
or what
it's a
city is
single
it in?
family. It's single family in city of LA.
Okay, so what we need to do is we need to serve a 3-day notice because they didn't pay the rent increase. You sent back the partial payment. We need to serve a 3-day notice and proceed forward with an eviction. If we serve the 3-day notice and they pay, great. You're enforcing your rights. But to move on to, so I don't want them sub-renting. Well, why are we even going there? They haven't paid you the rent.
I
Okay.
know. I just think that they're up to something, or that they're going to start,
Yeah, they're up to something.
sending
They're
us.
not paying the rent.
But why
Okay,
did
that's
they
what they're
send?
up to.
But they sent in a partial. I feel like they have an attorney advising them to do like
Okay,
some catch
okay.
22.
You're
All
thinking
right.
way too much, Diane.
I
Okay.
know. Okay.
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 Serve a
I know.
3-day notice. Have a good day. I swear, some of these landlords, they make me crazy. Eric S., how are you?
I'm great, Dennis. How are you?
I am fine, thank you.
I just have a question about the 3-day notice for this. Well, for the city, my property is in the city of Los Angeles, and I understand that we have to either mail or upload a copy of that 3-day notice to the portal, or mail a copy to the city within 3 days. I didn't do that. I didn't upload it on the website, but I actually mailed it.
Did you mail it within the 3 days?
I mailed it within the 3 days, but I did not take your advice. I didn't do a proof of service or tracking or anything. I just sent it by regular mail. So now the
Yeah.
tenant is saying that the city never received it, which they don't have any record of it either.
Well,
So
let
I
me
don't know.
explain why the city is saying that. The city is saying
Okay.
that because they're months behind in terms of the ones that are mailed in, getting
Okay.
them into their system. Let me ask you this. Have you already filed your unlawful detainer?
I have, yes. And this is
Yeah.
what
I
the
would go
tenant
down
is
to this. I
saying.
would go down to the city, and you might want to even talk to one of the people down there and casually ask them, how far behind are you in terms of the ones that are mailed in that you're uploading into your system, and then get that person's name, because when you go to court and they're going to claim that the city doesn't have it, we could, or someone could subpoena that person to come to court and testify that, hey, it's there, you're just months behind. And that is the truth. They're months behind.
So I guess
But
you're
you could
recommending
do
the
it with
regular.
a
Okay.
with that proof of mailing or certified mail like we have been doing.
So is it better for us to possibly upload it to the system as opposed to mailing it, or just do a proof of service
I've
or
gone back
tracking?
and forth on that. My office sends
Okay.
it by certified mail. We also
Certified.
have been
Okay.
uploading it too. I probably would upload it at this point, so you don't have to get to this situation.
All right. Thank you so much, Dennis. Have a good day.
Same to you. Okay, we're moving on to Tony C. How are you? Mr. Tony C., are you there? Okay, young sir, I am going to move on to NDCP. I'm going to ask you to unmute yourself.
Good afternoon, Dennis.
Good
How'd the
afternoon.
Lakers do? I didn't follow them.
Well, we've lost the first two preseason games, but we did win the last one against the Milwaukee Bucks.
Huh.
And we have another game coming up. I think it's Phoenix on Tuesday, all preseason. And LeBron's son, with all due respect, doesn't look so good.
Mhm.
But in any event, how can I help you?
Okay. I have a proceeding route for eviction with violation of rental agreement, but I also want to give a 90-day notice of raising the rent. So if I do the 90-day notice to raise the rent and then follow up with a 3-day notice because of rent violate, agreement violation, is that any value added for doing it in that way?
I think it's certainly proper to do it that way. There's nothing wrong with that. You're saying, hey, I want my rent to be increased in 90 days to this amount. And then a few days later, you're serving them a 3-day notice. Hey, by the way, get rid of your dog. I don't see them inconsistent with
Okay.
this. So I think you're fine on that.
Okay, because we're also looking to get the building and safety people in to do a citation on this hoarding. And
Right.
that's going to be, I guess, helpful for the 3-day, right?
You
Path.
got it.
Okay. All right. Thank you, Dennis.
All right. You take care. We're going to move on to Kathy Campo. I think you're going to be our last caller. How can I help you?
Hi, Dennis. We spoke the other day when I was headed to LAX. Thanks for taking my call again. Um, I wanted to know, I was reading online that, so I have a single family dwelling in Ventura, and we talked about I'm exempt from, I guess is it AB 1482? Um, if that is the case, I read that I must provide a notice to the tenant that of the exemption. Is that correct?
When did your tenant move in?
The tenant moved in June 1st, and it's a 1-year lease.
Okay, that exemption language had to have been contained in your rental agreement. If it wasn't, then your property is subject to AB 1482. It is not subject to rent limitations once that lease expires, but you are subject to good cause.
Ugh.
Any rental agreement entered into after November of 2020 has to have the exemption language in the lease. If it doesn't, then you are, even though otherwise it would be exempt from statewide rent control, you are now subject to statewide rent control. So, for example, if you wanted to sell your property and you just wanted the tenant to move,
Yeah.
that would not be a proper reason.
So I can't do any type of addendum that would.
No,
Nope.
they had to have been contained. Now, if you get them to sign a new rental agreement that has it, then you're okay.
Okay. And one other quick question. If I want to raise the rent after the year lease, because I do not want him to stay on month to month. So as we talked about before, I can raise it up unlimited amount, correct?
Correct.
And then, so let's say it's 4,900 now, and I raise it up to 6,000, and he says, okay, no, thank you. And then I put it back on the rental market. If I put it below the 6,000, can there be any repercussions to that?
I don't think so. I mean, he could try to make some sort of a claim that you're directly trying to evict him, but your position is, hey, I checked out the market and I talked to a few brokers and they all said that I was going too high. Anyway, thank you very much. This is going to conclude the latest edition of Zoom Landlord Tenant Talk Radio. Once again, our programming will be on next Saturday. I believe that's the 19th, and it will always be on Saturday from this point forward. I do appreciate everybody joining me. We had a lot of questions today. I was worried whether you guys would find me on a Sunday. But anyway, thank you. Have a great rest of your weekend and signing off. Take care.